Hello and welcome, everyone. Thank you for joining us, logging on, and joining us for our first of many webinars. My name is Liz Niles, and I'm joined by Britt Burner, who will be discussing estate planning for all ages. We're from Burner Law Group. Today, we'll be discussing part one. This is a two-part series. We will be having the second part on Thursday by Robin Burner Dalio. We will be hosting these seminars weekly on every Tuesday and Thursday at 2 o'clock moving forward, and we hope that you can join us. All of our webinars will be recorded, and we will be able to share those on our website as well as our social media platforms. So we encourage you to visit those both and share them with your friends and family. Britt will be leaving some time at the end for questions if anyone has any. If you do scroll over in your panel, you'll see a question area. So if you have a question that comes up, please feel free to put it in there and we will try to get to everyone. And at this time, I'm going to pass it on over to Britt and let her discuss estate planning for all ages.
Okay, everybody, good afternoon from wherever you are joining us, probably from your living room, just like the rest of us are. And I think something that's really important from our law firm is that we've always felt really strongly about educating those around us, those in our communities, about the topics that we work on a daily basis. And it's no different now. We're just coming to you a little different way. There's sometimes a little kinks in the electronics of it, but we're making our way. And so we're really happy to be able to bring you this content in a different manner. So today I'm going to be talking about the basics of estate planning. It's the part one. And really what I want to talk about is, what is a will? Why would you have a will? What happens if you don't have a will? What is the probate process? And all of the things that surround that. I plan to talk for about 30 minutes with some, as Liz said, question and answer at the end. Please type your questions and answers into the box provided and Liz can read them out. So with that, I'm going to get started. So probate, wills. A will is a document. You sign it. It needs two witnesses. That is the simplest way I could describe a will. It says how you want your assets to be distributed at the time of your death, to whom you want them to go, how you want them to go. Do you want them to go outright? Do you want a trust? What kind of restrictions do you want in that trust? And it also says who's going to be in charge. So this is the executor. The executor of your will is the person whose job it is to make sure that your wishes are followed. A lot of people will come to me and say, well, if they're the executor, do they get to choose how the assets are distributed? And that's not how it goes. The executor is following the rules laid out by the will document. So like I said, to validly sign a will, you need to have two witnesses over the age of 18. It can't be people who are named in the document as executor or trustee or to receive any bequests. And that makes a valid will. However, we go a second step, as do most attorneys, with what we call an attesting witness affidavit. So what that is an affidavit where those two witnesses swear that, one, the will was signed in the presence or the supervision of a drafting attorney, the attorney that drafted the document, presumably the person that advised you on creating the document, and that you were over the age of 18, of sound mind, explains if you had any defects of sight or sound, if you couldn't see or hear, how that was dealt with. And this document, this attesting witness affidavit that those two witnesses sign, is then notarized. So a lot of people don't realize that the will itself is not notarized. It's this affidavit that's notarized. And once that's notarized, we do it all right at the signing ceremony all at once. And we staple it all in the best of circumstances when we can. And then you have a full will, and it's self-proving, meaning that when that will is eventually brought forth after death, it is a completed document. It doesn't require affidavits from the witnesses at that time, because the will already includes those pieces of proof. So that always makes people say, okay, well, that seems simple enough. Well, then what's probate? Why am I always hearing that probate is so terrible and everybody wants to avoid probate? The probate process requires a will, and a will, if it's going to be followed, requires the probate process. The process of probate is when that original will, the original document, don't ever unstaple it, is brought to the surrogate's court in the county in which the person resided at the time of their death. The executor or the nominated executor is the person that we're assuming is going to be doing this, usually with the assistance of a lawyer that they've hired. And they fill out an application, a petition for that will to be, the term we use is admitted to probate. Admitted to probate means that the court is putting a rubber stamp on that will and saying, yes, this is a valid will. It has valid people who've signed it. And the executor is an appropriate person. They are now officially named as executor, because in the document you're nominated because the court has to actually appoint you. And then at the end of that probate process, the executor is issued what we call letters testamentary. And letters testamentary is the document with that raised seal. It's all sorts of colors, can't be photocopied, that you would bring to the bank, you would give to the different institutions to show that you are the executor and that you can do the business of the deceased person and collect and distribute the assets as you saw. So probate in many situations is not a bad process, or not necessarily even a long process. In some counties, it's a few weeks. Some counties, it's a month or two in a simple circumstance. So what do I mean by simple circumstance? So when you admit a will to probate, one of the things you have to do is notify the person's legal next of kin as to who it is that this will is being admitted to probate, who is looking to be the executor, and this gives them an opportunity to object. So, for example, for clients that I have who are unmarried, they don't have children, their parents are deceased, they might not have had siblings, they might have been an only child, and presumably their next of kin is somewhere in the cousin level of knowing, of relation. Well, then those cousins, all of those first cousins at the level where we find someone, have to be notified. So probate can become very difficult if those people are hard to find, because the court makes us show all of the due diligence that we put into coming up with who the next of kin are. And if we can't find those next of kin, we have to publish in newspapers. It could often require hiring a genealogist to help find who those people are or where they might live. And so for all of these reasons, if you're a person who does not have that close level of next of kin, probate could be a very long, drawn-out process after your death. Another time that probate could be a drawn-out process or difficult is if we know exactly who your next of kin are, but you're choosing to disinherit one of them. Take a single person with a son and a daughter, and they don't want to give anything to their son. They want everything to go to their daughter. Well, the will says that, and the will can name the daughter as the executor. But when she brings that will to court and embarks upon the probate process, she's going to have to give her brother a copy and either ask him to sign a waiver saying that he's not going to oppose the will, or he gets what we call a citation, which is a day that he gets to come to court and tell the court why it is that that will is invalid, and that could kick off depositions and litigation, and it gets very timely and very expensive. So that's another person who is likely going to want to avoid the probate process. So far we've named two. So if you have next of kin that we can't find, or if you're choosing to disinherit your next of kin. The next category of people that I would say we often would advise that they avoid probate is if you own real property in multiple states. So that's if you own dirt in multiple states. So I'll give you an example. You may be someone who owns a home in New York, or maybe rents in New York, and you have a small little log cabin up in Massachusetts and a condo down in Florida. That's 3 different states that you own property in. which means that your will would have to be probated first in the state in which you are a domiciled at the time of your death. Where do you live? So what is your legal residence? So because we're in New York, let's say that's New York. And then there'll have to be what's called an ancillary probate proceeding in Massachusetts and Florida. And you'll have to usually hire an attorney in those jurisdictions and go through the process there. And in many states, the process of probate could be a lot longer than it is here in New York. And every state has a different process. So I should have said at the beginning that everything I'm telling you is a New York specific advice, New York specific information. And everything is based on New York law. My understanding of other states from talking to other attorneys that I know is that in other states, probate can be very expensive and it can be very drawn out, even in the simplest of circumstances. So often, if you do own property in multiple states, we are going to want you to avoid probate. Another time that often people want to avoid probate is if they have a disabled beneficiary. Often, if there's a disabled beneficiary that can't represent themselves in the probate proceeding, then there is a guardian ad litem who's an attorney off of the court's list who's appointed to represent that person's interests. They write a report, and each county surrogate's court deals with the guardian ad litem a little bit differently. But what it comes down to is in the case where that protection for that individual isn't needed because of the family structure or whatever it may be, we can provide for that disabled beneficiary without going through the probate process, which avoids the fees to this additional court appointee. So those are really, when we're talking to our clients, the four main times that we want clients to avoid the probate process. So we can't find your next of kin. We can find them, but you're choosing to disinherit one of them and we expect there to be a conflict. You own property, real property in multiple states, or there's a disabled beneficiary and we want to avoid the extra court appointees. So those are the main times we want to avoid probate. But in most other situations, probate is a fairly simple, fairly quick process and doesn't necessarily need to be avoided at all costs. When we have clients who do not have a last will and testament, I should back up, all of the assets that go through the probate process are assets that are in somebody's sole name with no beneficiary. So what does that mean? If you have a checking account that is joint with your spouse, you own your home joint with right of survivorship or tenancy by the entirety with your spouse, you have a retirement account of some sort, an IRA, a 401k, and that has a beneficiary named, and those are your only assets, then no matter what your will says, there is not going to be probate of that will because there are no assets in your name that require distribution according to the terms of the will. So to take that a step further, what that means is if all of your assets name your spouse, but you really wanted some of those assets to go to your children and you put that in your will, maybe it's a second marriage or maybe you just wanted things to go to your children, that won't happen if none of the assets are in your sole name with no beneficiary. Take the same person that I just discussed, and maybe all of the assets are joint with the spouse or name the spouse as beneficiary, but there's one bank account with $100,000 in it that's just in the deceased person's name. Well, that account with the $100,000 in it is going to be the only account that passes through this probate process and the only account that is divided up according to the terms of the will. I had a client once who came in with 26 different beneficiaries that she wanted to put into the will as named beneficiaries. But when we actually went through what all of her assets were, she had one bank account that wasn't otherwise designated to go to somebody without the probate process, and it had less than $5,000 in it. So it was the first time she had realized that those 26 people on that list were all going to be dividing up that $5,000 after the costs associated with probate. And so obviously, once we realized that, we changed her plan, and we could change what the designations were on the beneficiaries, where she had joint accounts, and move things around. What we're going to talk about next week are trusts, different types of trusts. And putting assets in a trust is one way that we avoid probate, because remember, I said you avoid probate by having assets that are not in your sole name with no beneficiary. Well, if the trust is the owner of an asset, that's not in your sole name. Again, like I just said, if you have a joint owner on an account, or if you have a beneficiary named on an account, those things are all going to serve to avoid the probate process as well. So when you're sitting down with an attorney to go through what you want in your will and what you want your estate plan to be, it's very important to be very upfront and honest with the attorney about what all of your assets are. Because if the attorney doesn't know what all of the assets are, then the attorney is not going to be able to properly tell you how to divide them up and how to make sure that assets are going to the people that you want them to go to. I see there's a question now. So Liz, can we take that question now before I move on?
Yes, so the question is from Anne. She says, suppose first cousins are deceased. Does one look to second cousins for initiation of probate?
So the way the family tree works, I'm a very visual person, so you can see my hands. So it goes down the bloodline and then up the bloodline and then over. So it's myself, my spouse, my children, my children's children, all the way until my bloodline has finished. Then it goes up my bloodline to my parents. If my parents are deceased, it goes to my siblings. Then it goes all the way down their bloodline. Then if there is nobody in that bloodline, it goes up, and now we go to the parents of my parents, and then all of the children they had, and down that bloodline. So you can continue on. If you can imagine the loops of the branches of the top of a tree, a weeping willow, that's what we're looking at here. And we get all the way to the bottom of a family line before we go back to the top. But whatever line you find someone at, you stop there. So if I find, the first cousins, then I stop at that line. Okay. So the next thing that I'm going to talk about is what happens if somebody dies and they do not have a will. And again, they do not have any beneficiaries named on their assets, and they don't have joint owners. So they have a bunch of assets that's in just their name, and they've died and they haven't directed it to anyone. A very similar court process happens. It's called administration. The difference with administration, the two main differences, you lose the choice. So you don't get to choose who the executor was, and you didn't get to choose where the assets go. Because when you have a will, you're picking both of those things. So if you are a person who has not done a will, and again, let's take that same $100,000 checking account, there is a list in the law of those persons in a hierarchy that can be the administrator of your estate. It's a very similar job to the executor, but again, the executor is only because they were in a will. So the administrator is certain people that can be appointed, and there's a level of closeness they have to be to you. So I had someone who came in once and they said, my good friend died, my good friend, their neighbor, and I think they have a sister in Pennsylvania somewhere, but we need to get the administrator. We need an administrator of their estate. There was no will. Well, that sister in Pennsylvania may not have talked to that person in 20 years. They may not be able to do it. They may not be interested in doing it, but that's the person who is the appropriate person. If she won't act, we would hope she would sign a renunciation. She could step down. Perhaps she could nominate the friend and say that the friend can act. If not, then we get all the way down to nobody will act. There's what we call the public administrator. The public administrator charges a pretty high fee. They have, every county has a public administrator, and they will go in, and it takes a while, but they will eventually become in charge of that estate and distribute it. And again, remember, they're distributing it not to anyone that the person who's deceased chose. They're distributing it according to that family tree again. So it doesn't take into account the wishes that a client has. So if a client comes in and we're talking about how they want their assets to be distributed, one of the first things I ask them is, let's talk about your family tree. Let's talk about who is in your family tree and how you feel about them. It's not because I'm trying to be nosy, it's because I'm trying to figure out what's going to be the best plan for that individual person. So some people come in and believe that they need to avoid probate because they saw something on TV that said that probate is a nightmare and they have to avoid it. And once we sit down and we go through these steps of what would probate look like in your situation, probate might not be so bad, and they might be able to move forward with a will rather than a trust. And then there's other people who we sit down, and once we really start to get down to it, their next of kin is a very combative sibling. If there's, or they don't have that next of kin, they don't have anyone close to them. And then we want to be looking at beneficiary designations. We want to be looking at what kind of assets do they own? Where do they own them? Is it that little log cabin in Massachusetts that might only be worth $20,000, but it could cause a big mess in having to probate in multiple states? I see somebody raised their hand, but I think the best thing to do is if you, on your screen, go to the Q&A, and you can type a question in. Okay, I think we have one last.
But we just had another question come in. Great. From Kathleen. Can you give an estimate of a typical price of probates in New York State? Court cost, attorney costs?
Ooh, I wish that one of the attorneys who knows this better than me knows. The attorney costs vary. It's very hard to say. I know that some attorneys will bill their time hourly. That's generally what we are going to do, what we do in our firm. So we would ask for an upfront retainer, and then it just depends how long it takes, because there are so many unknowns when dealing with these things. Whereas I know some attorneys take a percentage of the estate, and so that is going to vary quite a bit. Don't quote me, but I believe, and if any of the other attorneys from our office are on and want to write in the Q&A and say if they know the answer, I think the highest filing fee is around $1,000, maybe a little more for the court. But if it's an estate of less than $50,000, it's what we call a small estate, and it's a $1 filing fee.
Okay, now Joni has her hand raised. Joni, if you have a question, if you go over to the question and answer panel, if you can type in your question, we'd be happy to answer that for you.
We'll see if that question pops up. If not, okay. So like I said, we're going to discuss trusts next week, and I think that in order for people to understand the value of some of the trusts, every trust has a different purpose, but understanding this concept of probate and this concept of administration really lays the foundation for all of that. Because if you don't have an understanding of what this probate process is and what it's all about when everybody's talking about avoiding it, well, then you can't really understand the value in trying to avoid that process. The other thing that a will does often is, so when we have a will, we often waive the requirement of a bond. So a bond is security on the account. I always compare it because people watch on TV, Law and Order, bail or bond. That's the security that you're going to come back to court when you're supposed to, when you've been arrested and you've been released. Similarly, a bond in an estate is a security on the executor. A lot of times we waive that if it's a family member serving as the executor, because that is just a premium amount that has to be paid, and that draws down the funds of the estate. The other thing that I think is important to note is that the executor, once appointed, or the administrator once appointed, now they have the right to act on behalf of that estate. Realize that if somebody was supposed to be filing tax returns, who's going to sign the tax returns if they're deceased? Well, if somebody has been appointed to the estate, they have that authority. Or what if we have, someone needs to contact American Express, not just to freeze the card, but also to find out from American Express, what's the outstanding balance? Is there something we can do? How can we pay that balance? The debts of the estate are paid before the debts of the estate are paid before the assets are paid out to the different people in the will. And so it's very important that the executor understands that that's their job. Now, if a family member that I am the direct heir of, say a parent, were to pass away and they have zero assets, but they have $100,000 in debt, I'm not going to inherit their debt. However, if they had $100,000 in their estate, the executor has to make sure the debts are paid before they make any distribution to me. Liz, do you want to ask those additional questions?
Yes, we just had 2 more questions come in. We have one from Eileen. She wants to know, can the same person be an executor and the beneficiary?
Yes, they can be, and they often are. Many times people are naming their spouse or their children or whoever their next of kin, who they're closest with, is their most trusted person. They're naming them as executor, and then that person is also a beneficiary.
Okay, thank you. The next question we have is from Bonnie. She wants to know, if a married couple has all joint assets, can there be other beneficiaries' children if one person dies, or do all the assets go to the surviving spouse?
If everything is joint, it all goes to the surviving spouse, because if it's joint with right of survivorship, that is, they own it jointly, and that's how they own it. However, if a spouse dies and their will, there's 2 things. One is, if one spouse dies and they've left nothing to their surviving spouse, that surviving spouse has what we call a right of election. So they have the right to demand 1/3 of the estate be paid out to them. New York State doesn't let you just disinherit your spouse and get away with it. If you die and you have a spouse and children and you don't have a will, then the first $50,000 goes to your spouse, and the balance of your estate is split 50-50 between your spouse getting 50% and your children getting 50%. So if that is something to really pay attention to. I had a client who came in and the husband had died many years ago. And she came in with her adult children to do some planning. And when we actually looked at the deed to her house and realized the date of purchase and the date of her husband's death and all of that, we realized that what it came down to was if the estate had been dealt with, and it hadn't been, and we had to eventually deal with it, half of her house actually belonged to her children, because that's how the assets would have distributed, because he died without a will. So it's very important to pay attention to that.
Okay, that's it for questions at the moment.
Okay, great. So the other thing I wanted to point out about the will, what we put in the will, is that people always say, well, how do I give it away? What do I give? How do I write it? And we have 2 things. We have specific distributions, and then we have what we call the residuary. So think of specific distributions as giving specific items to people or a dollar amount. So I give my photo collection or my stamp collection to my daughter, and I give $25,000 to each of my grandchildren, $25,000. And then the residuary is, I've got 100% of my estate, and I want to divide it up in these percentages or in these fractions. And those specific distributions come off the top. So if I have $25,000 to my daughter and my estate was only a $50,000 estate, then $25,000 will go to my daughter, and then the $25,000 that remains will be divided up amongst those residuary beneficiaries, no matter how many there are. So again, that's something to also pay attention to when you're sitting with the lawyer and making decisions, to make sure that the people that you've intended assets to go to will actually get them under the scheme that you're creating. Are there any other questions? I'll give it a minute. While I give it a minute, I'll just say that, so again, these, oh, yeah, go ahead.
We have one question coming in. It says, it is my understanding that a deed trumps a will.
So if a deed says that my sister and I own a property joint with rights of survivorship, and my will says I give my property to my best friend, then yes, the deed will trump. But if my deed says I own a property with my sister and it's owned in a way that we call tenants in common, which is basically 50-50, and my will says any interest I own in my house goes to my best friend, well then after my death, my sister and my best friend are going to own a house 50% each together.
Okay, I don't see any additional questions. Britt, did you have anything else that you wanted to discuss? Because we're about at our time at this moment.
Yeah, I just want to thank everybody for joining us. Again, this is the first time we're doing this, and anyone who's on this webinar who has heard me speak, mostly I'm speaking here in New York City, knows that it's very hard for me to keep anything to 30 minutes. So I was trying very hard. But we really are just trying to give you information in a way that you can digest it. And we're really hoping to build on it. When Robin is speaking on Thursday, she's going to be speaking about power of attorney and healthcare directives. And then we'll build into the trust next week. And the following week, we're doing a 2-part series on Medicaid. I also just want to add that today is March 31st, and we anticipate that the governor and the legislature is in the final stages. I was checking my emails right before I got on here of creating the budget for the 2020-2021 year, which is going to likely include a lot of changes to the Medicaid long-term care program. And what we're hoping to do, that's why we put the Medicaid one out about 2 weeks, is we really want to digest what those changes are. And we anticipate we're going to be able to bring some of those changes to you and the effective dates of them and all of that on that webinar in 2 weeks. And, you know, our firm is, we're still here. We've got, I think we're about 35 or 38 women working all from home right now.
38, yep.
38, yep.
Yep, and we're all working remotely, so we are 100% up and running.
Yeah, and we're here to answer any of your questions. I think there's some additional questions there, Laura.
They're just thank yous. We've got Gail saying, this has been great, Britt. Thank you from Brookdale Battery Park. We've got an anonymous, thank you so much for getting this great information to all of us. Great job, ladies. Thank you. Thank you for making this available. So we want to thank you as well from all of us at Burner Law Group. Like Britt mentioned, this is our first of many. We will be doing weekly webinars on Tuesdays and Thursdays, so we hope that you can join us moving forward. Robin will be presenting part 2 of this on Thursday, so if you haven't already registered, please go ahead and do that. You can do that right off of our website. We do have a pop-up. And again, these will be recorded for your reference, and you can share with your family and friends and whoever you think can find this information useful.
Okay, be well, everybody.